Hi there, I'm Iana. I'm the Whistleblower Protection Coordinator for the U.S. Department of Health and Human Services. Now, in addition to being the coordinator, I'm also a supervisor in the Office of Inspector General, Office of Counsel to the Inspector General. So in this role, I completely understand the challenges supervisors face, especially when you're trying to determine what to do if you receive a protected disclosure from an employee, contractor, or HHS grantee. That's why we produced this video for you. My colleagues and I are here to help you better prepare for the challenges you might face if and when a protected disclosure arises. In this video, we'll answer some of the following questions you might have, such as, what is a protected disclosure? What are employees, contractors, or grantees required to report under HHS regulations? What is the role of the Office of Special Counsel when it comes to whistleblower protection and retaliation? What responsibilities do you have as a supervisor when responding to protected disclosures? Now, before we go too far, if you're looking to understand the basics of whistleblower protections, we definitely recommend that you watch our Whistleblower 101 video first. After watching that video, you'll watch this video with a solid understanding of whistleblower protections. That way, you'll get more out of this video, where we help you understand what to do as a supervisor when someone approaches you about wrongdoing, as they're encouraged to do in the Whistleblower 101 video. But if you already have a handle on those basics, let's move on. First things first, let's start out by making sure we're all on the same page with what whistleblower laws protect. Let's hear from my colleague, Melissa, as to what whistleblower laws protect.
Whistleblower laws protect individuals from receiving an unfavorable employment action when they make a protected disclosure. What is a protected disclosure? A protected disclosure is a complaint of fraud, waste, or abuse, unlawful activity, or a danger to public health or safety. It's important to understand that not everything is a protected disclosure. A few examples of what are not protected disclosures include EEO complaints related to violations of Title VII of the Civil Rights Act, grievances, labor law violations or workplace disputes, and unlawful disclosures of information, such as the disclosures of classified information to the media.
All right, with that foundation, let's get into what we are required to report as HHS employees and supervisors. Before we get into the technical details as to why reporting is mandatory, I want you to hear from our team as to why reporting is critical to our mission.
It's important to report cases of fraud, waste, and abuse because we need to protect the Medicare Trust Fund and protect our beneficiaries.
I think that it's important to report fraud, waste, and abuse because the American public expects their departments and their employees to work with integrity.
So, as you can see, reporting any issues of fraud, waste, and abuse is critical to ensure the integrity of the work that we do. But let's hear from my colleague, Marcus, about those technical aspects we mentioned earlier.
Now, you might not be aware of this, but HHS regulations require that HHS employees immediately report information that they reasonably believe indicates the existence of civil misconduct. Civil misconduct is defined as a possible violation of a rule or regulation of the department, mismanagement, a gross waste of funds, or abuse of authority, or a substantial and specific danger to the public health and safety. Now, HHS regulations also require that HHS employees report information which he or she reasonably believes indicates a possible criminal offense against the United States by an employee of the department or any other individual working on behalf of the department. This includes issues such as bribery, fraud, perjury, conflict of interest, misuse of funds, equipment, or facilities, and anything else that is prohibited by Title 18 of the United States Code. Any offenses under these statutes should be reported to the Office of Inspector General or an HHS supervisor or management official.
Thanks, Marcus. It's important for employees to understand when they must report wrongdoing to our investigators. Now, there's always one question that comes up, and it might be the first you're asked about as a supervisor. So let's cover it here. Identities of employees who report matters to the OIG will not be disclosed without their consent unless it is unavoidable or necessary during the course of an investigation. So, knowing that HHS employees are expected to report misconduct and criminal offenses, it's important to understand that HHS regulations specifically prohibit supervisors or anyone else in authority from taking personnel actions or even threatening to take a personnel action against an employee in reprisal for filing one of these complaints. Melissa, aren't there laws and regulations that talk about this?
There are, Iana. The HHS whistleblower reprisal regulations are further supported by the Whistleblower Protection Act, Presidential Policy Directive 19, and the Military Whistleblower Protection Act. These acts prohibit retaliation for the reporting of protected disclosures by federal civilian employees and U.S. Public Health Service Commission Corps officers. In fact, under the Dr. Chris Kirkpatrick Act, supervisors found to have retaliated against a federal civilian employee for making a protected disclosure may be subject to no less than a proposed 3-day suspension for a first offense, or termination for a second offense. So, retaliating against an employee for making protected disclosures carries severe consequences. As if any more reasons were needed for mandatory reporting, HHS contractors and grantees are also required to report criminal violations related to an HHS contract or grant under the Contractor Code of Business Ethics and Conduct in the Federal Acquisitions Regulations, and in the grantee mandatory disclosures found in 45 CFR. Employees of contractors and grantees are protected from retaliation under the National Defense Authorization Act of fiscal year 2013, codified at 41 U.S.C. 4712. Say that 5 times fast. I'll wait.
So, no matter how you look at it, any act of fraud, waste, or abuse must be reported. It's one of the best ways to ensure the integrity of the work that we do. Now, let's talk about what you need to do when you receive a protected disclosure as a supervisor. As an HHS supervisor, you're actually required to handle protected disclosures in your care appropriately and seriously. Employees cannot be disciplined or experience any unfavorable personnel action or threats for reporting information regarding misconduct or criminal activity to the OIG or HHS management. That's actually considered whistleblower retaliation and may be subject to discipline. While the process often depends on the allegation that's being made, my colleagues are going to share the preferred steps to take when you receive a protected disclosure.
As a supervisor, the first thing you'll want to do is to have a conversation with the employee. Do what you can to gather information to review the issue yourself. In this conversation, you're looking to establish 3 key things. Number 1, what are the allegations of wrongdoing? Are they mismanagement, waste of government funds, abuse of authority, violation of law, rule, or regulation, or a substantial and specific danger to public health or safety? Number 2, what are the facts supporting these allegations? And number 3, whether the complainant is alleging retaliation for reporting the wrongdoing.
Knowing this information can assist you in determining whether you need to refer the matter to the OIG or if the wrongdoing is something that your agency can rectify. For example, if the employee is alleging that an NIH employee is a close friend of the CEO for a company bidding for an NIH contract, this issue possibly could be rectified internally by the employee recusing themselves from the bidding process for this procurement. If, however, it is alleged that the employee is receiving compensation from the friend to secure an NIH contract, a referral to OIG and the NIH Division of Program Integrity would be more appropriate. It is highly advised that in these situations, you confer with the appropriate individuals within your agency, including your internal affairs office, ethics shop, or legal counsel. Remember, you can always ask the OIG. We're here to help.
Now, if the individual is a contractor or grantee employee, you'll want to provide them with an NDAA Whistleblower Rights Notice. You can find a copy of this on the OIG's website.
You'll also want to determine if the individual is making a protected disclosure of wrongdoing or retaliation. If it's a disclosure of wrongdoing, encourage the person to file a complaint directly with OIG Hotline. You can also refer the complaint to OIG if the allegations are criminal or constitute improper conduct that would fall within OIG's jurisdiction. For example, gross waste of funds, gross mismanagement, or conflicts of interest.
If it's a disclosure of retaliation, your choices vary depending on the category of the employee involved. If the individual is a civilian federal employee, refer them to the Office of Special Counsel, or OSC, which is a federal agency that investigates 14 prohibited personnel practices, including whistleblower retaliation complaints made by federal civilian employees. Here at the OIG, we also have jurisdiction to review civilian retaliation complaints, but we don't have the prosecutorial and enforcement tools that the OSC has. If the individual is a U.S. Public Health Service Commission Corps officer, encourage them to file a retaliation complaint with the OIG. They can do that at the following link, or they can call 1-800-HHS-TIPS, TIPS. And if the individual is an employee of an HHS contractor, subcontractor, grantee, or subgrantee, encourage them to file a retaliation complaint with the OIG at this web address, or they can call 1-800-HHS-TIPS.
So when in doubt, give the individual the link and the hotline number. And if they have more questions about their whistleblower rights, they can email us at whistleblower.coordinator@ohg.hhs.gov. The individual may be stressed with the situation they just encountered. Reaching out to us will provide them an opportunity to report their disclosure in a setting that might be a little more comfortable for them. And from your perspective, you can rest assured that you're doing the right thing by pointing them in the right direction. We have an entire team that's extremely well trained in handling these types of situations. More importantly, we're here to make them feel comfortable, and we're here to help. Okay, so since we're preparing you for all aspects of whistleblower situations, it's important that you understand what to expect if OIG conducts a whistleblower retaliation investigation. As a supervisor, you may find yourself being contacted by an OIG investigator as a part of a retaliation investigation. The Inspector General Act and HHS regulations require that HHS employees cooperate with and assist the OIG as a part of its investigations. This also means that any records requested by the OIG during the course of its investigation must be timely delivered. Please note that OIG investigators do not need warrants or subpoenas to obtain records from HHS agencies. An information request from OIG triggers your legal responsibility to cooperate. HHS contractors and grantees are also legally required to cooperate in these investigations. Now let's hear from my colleague Melissa about what happens when OIG investigates a retaliation.
When OIG investigates retaliation, the OIG team is looking for evidence to meet the following elements of proof. First, the employee's burden of proof. This includes evidence that a protected disclosure was made by the employee, that a personnel action was taken, not taken, or threatened against the employee, that the responsible management official who took the personnel action had actual or constructive knowledge of the employee's protected disclosure, and that the protected disclosure was a contributing factor to the personnel action taken against the employee. If these four elements are met, the OIG then looks for clear and convincing evidence that the employer would have taken the same action absent the protected disclosure. This is known as the employer's burden of proof. In making this determination, OIG reviews the strength of the evidence supporting the personnel action, the existence and strength of any motive to retaliate, and treatment of similar employees who are not whistleblowers, for example, comparator evidence. It's important to remember that you must provide all of the records requested by the investigator during the inquiry and cooperate in interviews. Whistleblower retaliation investigations are administrative in nature, not criminal. However, a failure to cooperate in an OIG investigation could lead to disciplinary action under the HHS residual standards of conduct.
So, there are a lot of things that you should expect during a whistleblower retaliation investigation. But you might be wondering how exactly you should handle the conversation if an employee comes to you with a protected disclosure. Let's discuss. As a supervisor, the simple truth is that you may find yourself on the receiving end of a protected disclosure. If that's so, it's important that you handle this request with the diligence and respect that it deserves. With that in mind, let's go over a few tips that you can use when having a conversation with an employee who reports retaliation or wrongdoing.
It's important that supervisors encourage it because we want to make sure that our employees feel comfortable with reporting what they see as fraud, waste, and abuse.
First, be supportive. Do not express doubt or attempt to dissuade them from reporting the unlawful activity. Remember that employees may be required to report when they reasonably believe they have evidence of civil misconduct or criminal activity. Second, determine what the employee hopes to accomplish through the conversation. Find out if the employee is requesting an investigation into the matters they are reporting, or simply looking for resources on how they can report the information. For example, how to contact the OIG. Or maybe they're just trying to find direction as to next steps. Next, you can determine anonymity requests, but don't make any promises you can't keep. As a supervisor, you want to help, to be supportive, but there are instances in which we cannot maintain anonymity, particularly if the federal employee is reporting gross misconduct, retaliation, or criminal activity. If this is the case, you need to consider the type of employee that you're communicating with. If it is a federal employee, let them know that as a supervisor, you are obligated to report certain matters to ensure they are properly investigated. When employees express a desire for anonymity, inform them that the OIG will take anonymous complaints and provide them with information for the OIG hotline. If the employee is a contractor or grantee, and you possess contract or grant oversight responsibilities, try to address the allegation being reported with the contractor or grantee without reporting who disclosed it to you. Trust me, we often see instances where employees of contractors and grantees were in fact terminated because they reported what they believed to be unlawful activity to the HHS employee who oversees the contract or grant. This means that your disclosures to the contractor or grantee could result in someone being retaliated against. So be mindful of disclosing any identities when you don't have to. Disclose the problem, not the person.
Stay open and receptive to an employee's disclosures of wrongdoing, even if the disclosures don't appear to meet the legal definition of whistleblowing. Refrain from making a judgment call as to whether the employee is making a protected disclosure or not. Remember, an employee doesn't have to be right about the conduct being unlawful in order to be protected from retaliation. They just have to have a reasonable belief that what they are reporting is unlawful. Don't try to make that decision for them. Just treat the conversation as protected and look into the matters appropriately.
And the last tip, provide resources. It's always acceptable to provide resources to federal employees and contractor or grantee employees when they come to you. Provide them with the OIG hotline information and NDAA notice of rights. Better yet, keep them handy so that you're able to point folks in the right direction. And be aware of any contacts within your operating division that should be notified, or to whom you can refer a complaint to, including HR, EEO, contracting officers, grants managers, and internal affairs investigators.
All right, that was a lot to take in, and that's all of the tips we have prepared for you right now. We hope this video has been a helpful and practical resource to you. If you have any questions, please feel free to contact us at whistleblower.coordinator@oig.hhs.gov or visit our website at www.oig.hhs.gov. Remember, we're here to help.